you all for joining us today for our presentation on the Mandamus. My name is Dustin Saldarriaga, and I'm a Senior Associate with Scott Legal PC in New York City. Our firm is a business immigration firm. We do, however, handle all issues related to U.S. immigration, whether that is litigation, as we'll be talking about today, whether that is family-based immigration, temporary visa options like student visas or visitor visas, or, as I mentioned, business-related visas, and that includes the E2 and treaty investor visa, EB5, job creation green card, etc. So we do hope that regardless of what immigration questions you have, whatever immigration issues might come up, you don't hesitate to reach out to our firm. A few housekeeping items before we get started. As I mentioned, our firm is a full-service immigration firm, and actually the founder of our firm, Ian Scott, is currently on an E2 visa. He has personally navigated a number of visas, not just the E2, but also the TN, the H-1B, the F-1. So the fact that he has navigated the process really does inform how we work with our clients, his experience going through the process firsthand. And we do think that shows in our relationships with our client and the way we provide our services. This webinar is part of a series. We try to do at least 2 webinars a week. And these span a full range of immigration topics. We do record our webinars, so this webinar is being recorded. We put the full-length webinars up on our YouTube channel. We also post to our YouTube channel shorter videos, so we do hope you'll check that out and find it helpful. After this webinar, we'll send you an email with a link to our YouTube channel, a link to our blog on our website, a link where you can sign up for future webinars, so really, and also our contact information. In case you do have questions that are specific to your circumstances, we do recommend that you schedule a consultation so we can talk about the details of your circumstances. If you have any questions during this presentation, do send them in through either the chat function or the Q&A function on Zoom. I have those open on my screen and I'm monitoring them. I will likely save questions for the end, but I do plan to get through all questions, so don't hesitate to send those in. All right, without further ado, let's go ahead and talk about mandamus lawsuits, or how you can overcome an unreasonable delay. So, a mandamus action, these are fun to talk about, and one of the things I like about them is the history. So one of the earliest Supreme Court cases in United States history is Marbury versus Madison, which involved a mandamus action. And so what a mandamus is fundamentally is when someone asks the court to tell the executive branch what to do. Or really not what to do, but to do their job. So you cannot file a mandate, we'll talk about this more, you cannot file a mandamus action to tell the executive branch to approve your application, but you can file a mandamus action to ask a court to tell the executive to decide the application. And you can see why this is relevant. Right now, the trends in terms of delays at the government, whether it's United States Citizenship and Immigration Services, the Department of State, which oversees all the consulates, delays are fairly extensive. So if you file, for example, an EB5 green card application, you could be waiting years before you get a decision on the I-526 petition, which is the first step in an EB5 application. So if you're waiting years for your I-526 or years, say, for your asylum application, you don't necessarily need to sue the government to approve your application, but you need to sue the government to say, hey, decide the application. I need a decision so I can move on with my life. Whether it's an approval, a denial, whatever it is, you need to do your job. You need to reach a decision. So that is what a mandamus action is. It is a lawsuit filed by the plaintiff, the person bringing the lawsuit, asking a federal judge to tell the government to perform an action that it is obligated to perform. So when we file an immigration application, we are paying an application fee to the government. The government doesn't have the ability to take that money and say, you know, we're keeping your money and we're not going to do anything. This is a scam. We're going to keep your money and we're not going to decide your application. The government can't do that. there are laws. Fortunately, Congress has passed laws. And so the laws say when someone files an application, the government has an obligation to decide that application, and it lays out, many times how they need to decide that application, what standards they need to look at, what qualifications. So the government can't just keep your money and do nothing. So it is obligated to perform an action. This lawsuit is asking them to do that. Again, the judge does not tell the government to approve the application, only that the government needs to decide it. Okay, so again, the result of a mandamus lawsuit could be an approval, a denial, or even a request for more information. If the result is a request for more information, what we typically do is we ask the court to keep the case open. We ask the judge not to dismiss the case just because the client's gotten an RFE. We say, Your Honor, please keep the case open because our client is going to respond to the RFE, and we want to make sure the government responds to that in a timely way. And then once our client has a decision is the point where we will agree to have the case closed, the case dismissed. So a mandamus action can be filed against U.S. Citizenship and Immigration Services, USCIS, a consulate, or other government entities that have a duty to act. Okay? So it can, for example, a mandamus action can be used to compel the government to process, for example, an immigrant visa, so an EB-5 green card, a non-immigrant visa, for example, if you've been waiting forever, say for an E-2 at a consulate, you could file a mandamus lawsuit to compel that. An application for work authorization, any number of applications. If the government has an obligation to decide the application and there is an unreasonable delay, then a mandamus lawsuit may be a good fit. And finally, while mandamus actions do look similar, so there is a certain process that generally takes place regardless of what you are asking the judge to compel, whether that's work authorization, non-immigrant visa, green card. Mandamus actions do look similar. In spite of that, in this presentation, we're going to focus on, in my examples, I'll focus on EB-5 applications. So I'm going to keep it very general, so this shouldn't get in the way of this being broadly applicable to other categories, but just know I'll be referring to certain forms, like the I-526 is the first part of an EB-5 application. I-829 is the second part of an EB-5 application, but we won't get into the weeds on that. Don't be discouraged. I'm just using the EB-5 as my example in this presentation. So what makes a strong mandamus case? And to phrase this differently, how long do you need to wait before you file a mandamus lawsuit? This is, in terms of mandamus lawsuits, this is the most common question. And I realized I do not think that I am sharing my screen. Let me go ahead and share that real quick. I apologize. Okay, so we will share this presentation after the webinar, so you will have this. Don't worry about taking extensive notes. So returning to the presentation, what makes a strong mandamus case? The first thing that is critical to keep in mind is that you are asking a judge to agree with you that the government's delay is unreasonable. So if you file a mandamus lawsuit when you have been waiting a few days, a few weeks, a month or two, it's very unlikely that a federal judge is going to look at that and say that's an unreasonable delay. So first step, the delay needs to be unreasonable. And there are a number of ways that when someone comes to us and says, I've been waiting, months and months or years, there are a few things we look at to decide whether a delay is unreasonable. The first thing we look at is the harm that the delay has caused to the person. And I think that's really important because in these discussions online or YouTube, when you learn about how people approach mandamus cases, oftentimes they give you a timeline. Well, for this type of case, you need to wait this number of years. That is relevant, and we'll talk about why in a moment. But I think the first thing to think about is what is the harm to the person? Because if you have been waiting a relatively short period of time, but let's say it is a life or death matter, that if you don't get a decision, a person is going to lose their life. Or if you don't get a decision, your business is going to collapse, and it is going to be financially catastrophic for, say, a number of employees of your business. You might actually have a good mandamus case on your hands, even if the actual delay hasn't been that long. So one of the first things we discuss with our clients is, what is the harm you have faced as a result of this delay? So going to my EB-5 example, the part of the EB-5 application is to apply to the government to remove the conditions on your green card. It's called an I-829 application. And this is a very important step if someone wants to become a citizen, which allows someone to vote. So one of the common arguments we will make in an I-829 mandamus context is to say to the judge, Your Honor, the government's delay is preventing our client from being able to vote in federal elections. That is a serious consequence of the government's delay. As a result, we need the government to act so that our client can vote. So thinking about framing the delay in terms of a real harm can really improve, strengthen your mandamus case. So let us, though, turn to the actual time frame. So because the time frame is important. When a judge looks at this, yes, they are going to consider the harm to the person who's applying for the mandamus, but they're also going to hear the government's arguments. Okay, so what is the government going to say, and how is that relevant to the time frame? The first thing the government's likely to say in response to your lawsuit is that the delay that you have faced as the plaintiff is not unusual. It actually is completely in line with the government's timeframes. And they're going to point to their published estimated processing times. So right now, if you go on Google and you Google USCIS processing times, you'll go to a website, a government website, where you put the type of form that you've submitted, and you can see how long the government estimates that application will take. If, in general, if you've been waiting a shorter period of time than the estimated time on that website for your form, in general, it is going to be a difficult mandamus case. In general, you want to wait longer than the published estimated processing times on the government's website. That being said, I'll give you an example. The EB-5, again, the I-526 form, which is the first step of the EB-5. A couple years ago, the government estimated that that form alone took more than 5 years for the government to decide. And we had a number of successful lawsuits where we would have clients waiting 2 years, 3 years. Even though the government said it should take 5 years, we successfully filed these cases. The courts agreed with us and would say, you know what? It doesn't matter. The government can say, they're saying 5 years. We think that estimate is unreasonable. So we are holding that a 2-year delay is unreasonable. Even though the government says it should take 5, we think that that estimate's unreasonable, and the period of time the person's been waiting, 2 years, is unreasonable. So you can certainly challenge the government's estimated processing times. Doing that, I think, personally, is one of the most fun parts of these cases, because the thing about suing the government is there's a lot of data. The government has to make public a lot of data. When USCIS, they have their filing fees. When they want to increase or change their filing fees, they need to go to Congress, and they need to disclose a ton of data to Congress explaining why the fees should be different. They've gone to Congress a number of times in the last decade. I'm not remembering the exact years, but I think it was 2016, 2019, and 2023 or 2024. And each time the government, meaning USCIS, goes to Congress and asks to change its fee, they disclose tons of data, including how many hours each form takes their employees to complete. So we are able to go to a judge and to say, Your Honor, the government is saying it should take them 5 years. They need 5 years to decide this application, this form, I-526. They've also told Congress 3 years ago it takes them a total of 20 hours to decide the application. 20 hours versus 5 years, clearly unreasonable. We also point to a number of other things, such as showing that the number of applications over time may be going down. So they actually have fewer applications on their hands to decide. At the same time, they're taking longer and longer. We can also look at their historical processing times, and we can say, they're saying 5 years now. Last year, it was 4 years. The year before, it was 3 years. The year before, it was 2 years. And we can show these trends, so it makes it very clear to a judge something is going on here where the government is not actually using its resources necessarily in the way they're claiming they are. And the judge says, you know what? I can't dismiss this case. I have to let this case move forward. And if that happens, the government is going to decide your case. That's basically what it boils down to. We'll talk about why in a few minutes. The next bullet. Has the plaintiff exhausted all administrative options? So what does this mean? This means you don't want to go to a judge and say to the judge, please compel the government to act, if you haven't taken all of the steps you possibly can. Think about this as, sometimes it's helpful to think of a judge as a teacher on a playground. And you are the plaintiff, you're one of the parties in the lawsuit, and you're playing in the sandbox with the government. The government is the other side of the lawsuit. The judge is the teacher. Okay, so if your friend knocks over your sandcastle, if the government knocks over your sandcastle, and you go to the teacher and say the government knocked over the sandcastle, the teacher is probably not going to stop everything they're doing, go over, and take a bunch of time to resolve this. They're probably going to say to you, well, have you tried to talk to your friend? Have you tried talking to them? Have you done this? Have you done that? And then only if you've exhausted everything, they'll say, okay, I'm going to put down what I'm working on. I'm going to go over. I'm going to see what's going on. A judge is very similar. And I use this expression because kids playing in the sandbox is a common expression when you think about lawsuits and how judges think. Judges do not want you to run to them when you haven't done everything else. They want to know you've tried everything and now they're going to step in because everything else has been tried. They are the last option. So what does this mean for you? This means, first of all, try to contact the government. Try to contact the consulate if that is where your application is pending. Try to contact USCIS. Even if you don't get through to everyone, document. I called this number on this date. I was put on hold for an hour. I never got through to anyone. Try reaching out to your local congressperson. They have liaisons who help with immigration issues, so document. I reached out to my congressperson, this congressperson on this date. My congressperson reached out to USCIS, and USCIS told my congressperson they're not going to do anything. That is a very common process. In the past, there was an ombudsman office, an office at USCIS that would oversee kind of the ethics and the processes. That office is not so active, though it may be worth reaching out to them nonetheless, just to show you took that step. You want to do things like this, okay, so that when you file your lawsuit, or I should say when we file lawsuits, we actually detail all that. On this date, our client contacted USCIS. USCIS did not respond. On this date, our client reached out to the congressperson. The congressperson got a response from USCIS that USCIS would not do anything. So a judge is seeing, wow, this person has actually tried everything they can. That makes it clear I have to do something. No one is going to do something if I don't step in. Okay, so that's what it means to exhaust all administrative options. When I say administrative, that's the agency's options. So you want to work with the agency, whether it's the State Department or USCIS, to exhaust your options. So we talked about is the process and rate at which the government adjudicates applications reasonable. That's the estimated processing times and how you can dig deeper. Don't just take the estimated processing times at face value. Actually look at the data. Are the processing times reasonable? There are also some excellent cases on this point. There's a case out of the Sixth Circuit that basically says that I'm going to butcher the quote, but basically the takeaway is a court is not satisfied with the government saying, hey, everyone, we're taking forever on everyone's applications, so this person shouldn't be upset. And the court is saying that's not enough. Like you can't just delay everyone's applications and that makes it okay. But the government really tries that argument. They try to say, look, we're going slow on everyone. So what gives this person who's suing us the right to sue? You need everyone to sue, or this person needs to show they're next in line, because otherwise they're trying to cut the line. They actually try these arguments, and they're a little bit, annoying and offensive. But we see the same arguments in most of these cases, and so we know how to anticipate this. We'll talk a little bit more about the framework and how to anticipate the government's arguments. Finally, the last bullet. Has Congress indicated how quickly the government should adjudicate the application? So fortunately, there is a statute. It's a general statute, and it basically says that Congress expects that the government will decide applications within a few months. That is the time frame. It's about 6 months. And so it is important to cite to that if there's not a more specific statute. For certain applications, such as naturalization applications to become a citizen, there is a specific timeline established in the law. So it's easy to go to court and say, Your Honor, look, there's a statute that says the government needs to do this faster, and they've taken longer than that. So those cases can be very straightforward. For many other cases, there's not a specific statute, so you would cite to this more general statute that I'm referring to. So let's take a big step back and actually talk about what the process is. So step one is you've been waiting a while. So you wait. Step two is you exhaust those administrative options that I mentioned before. So that would be reach out to a congressperson, reach out to USCIS, do whatever you can, Ombudsman's office, and see if you can get the application unstuck by doing that. Let's say that does nothing, which it's probably not going to do anything. At that point, you would file your lawsuit. So this is called a complaint. You file the complaint. You serve your complaint on the government. There is a specific address that you send your lawsuit to, whether you're suing the Department of State or you're suing U.S. Citizenship and Immigration Services, Homeland Security. You would also serve your complaint on the U.S. Attorney's Office that's representing the jurisdiction where you file. So if you live in Florida, you may file in Florida. If you live in New York, you may file in New York. And you would serve your complaint on the U.S. Attorney's Office in, say, the Southern District of New York if you're filing in Manhattan. Once the government gets your complaint, once you've served them your complaint, they have 60 days to respond. Okay, so people oftentimes ask, how long does it take to file a mandamus lawsuit and get a response? One of the first things I say is you are almost certainly not going to get a decision within the first 60 days, because usually what happens is the government will take those 60 days, they'll wait until day 55, maybe 58, and then the assistant U.S. attorney who's handling the case is probably going to reach out to you and say, can I have an extension of a month? Usually it's a good idea to agree to that extension because it shows, again, that you're playing well with the other person in the sandbox. The judge is going to want to see that the two parties are working together well. They're really trying to resolve this. So usually you would agree to the first extension. That's not always the case. Sometimes there are reasons to not agree to it. But generally speaking, you would. And then at the end of that period, they are going to reach out to their client. So the assistant U.S. attorney, that's the attorney who works for the U.S. Attorney's Office, they are going to be the main lawyer for the government. They are going to reach out to their client. Their client is going to be either the Department of State, Department of Homeland Security, meaning U.S. Citizenship and Immigration Services. They're going to pick up the phone and they're going to call the officer who's in charge of the application. So I want to pause on that because that is one of the key benefits of these lawsuits. It is not just that you have a judge deciding whether the delay is unreasonable. It is also that you have a government attorney who picks up the phone and talks directly with the person deciding your application. And that attorney is going to ask them, what's the status of this case? Is there any way to get this thing moving so that I don't have to go to court? Because attorneys' time is limited, They're not thrilled with these cases. They want to be handling their other big, important, newsworthy cases. These cases are fairly annoying to the attorneys. They would love to resolve them. So they're going to ask their client, is it possible to get this case decided? And at that point, either the Department of State, USCIS, whatever agency it is going to tell them, hey, here's where the application is. Sometimes they will decide it. I have been in the fortunate position of having the government say, you know what, I think we can resolve this quickly. It's wonderful when that happens because you can get a decision within 60 days, maybe 90 days. And then you're telling the judge, Your Honor, there's no need to move forward with this. The government has decided our application. That is wonderful. Usually, though, especially now, the Department of State or Homeland Security, USCIS, is going to tell their attorney, we are not negotiating on these cases. And if they tell their attorney that, then the attorney is going to say, we are either going to file a response to your lawsuit or we're going to file a motion to dismiss. Okay, and so usually they are going to file a motion to dismiss. And what a motion to dismiss is going to argue. Actually, we'll talk about this more in the next slide. But you see next, settle or litigate. Settle is what I was saying before, where the government says, you know what, we can decide this case. We can get this over with quickly. That's settling, okay? Because they give you what you want without you having to go in front of the judge. But if they say, we're not actually going to settle this, then they would file a motion to dismiss. Usually that is litigation. So then the judge is going to see the arguments of both sides and is going to decide each step of the case. We'll talk more about that in the next slide. Ultimately, though, the decision is the judge's if it doesn't settle. I'm going to move to the next slide. I have a habit of jumping ahead, so let's just move on to the next slide because I want to talk you all through how these actually play out. And what I was about to say, and I think it frames this slide well, is these cases almost never go in front of a judge where both sides are arguing like you see on TV. There's almost never a jury who's going to decide these. And there's a reason for that. And the reason for that is the government does not want to turn over documentation. Let's talk about what I mean by that. If the government says we're not settling this case, what they're going to do more often than not is file a motion to dismiss. And what a motion to dismiss says is to the judge, Your Honor, assuming that everything that the other side has said is true, assuming that everything in their complaint is true, they've been waiting the period of time, they say that, our process is unreasonable, that, everything you put in the complaint, assuming all of it's true, they still don't have a case. You can see how that's a very high bar. And usually motions to dismiss are not granted because it is such a high bar. But in the case of delay cases, in the case of mandamus cases, certainly motions to dismiss can be denied. Why? Well, this is why it's important to prepare a very good, strong complaint. Because you want to make it really hard for the government to say to the judge, assume everything is true in what they've written. They still don't have a case. You want to make it so that if you assume everything in your complaint is true, it's very clear you have a case. You're making all sorts of allegations about statements the government has made, trends in their data like we were talking about before, the harm to your client. If the judge assumes the harm is true, how could they possibly say you don't have a case? Okay? So you want to make it really hard for the government to succeed on their motion to dismiss. Let's say you do succeed. All right? And what that means is that the judge decides not to grant the government's motion to dismiss. What that means is the judge is saying this case is going to go forward. All right? I'm not going to dismiss the case. I'm going to allow this case to go forward. The next step is for you to ask the government for documents and information. You can do depositions. This is called discovery. So you get to do discovery. Okay? The government does not want to do discovery. They do not want to send their officials down to you or to have you come to them and depose them. They do not want to turn over to you their internal emails. They don't want to turn over to you their policies. Why would they have to do that? Because you've made an argument in your complaint that they have an unreasonable process. And you've made the argument in your complaint that over time, their processing times are increasing while the number of applications is decreasing. So clearly there's something going on, and you want the documentation to show what is going on. Okay, so you can ask for all that documentation. The government is going to do everything they can to not give it to you, which in your case means settling. So if you win on the motion to dismiss, 9 times out of 10, you are going to win your lawsuit. The government, the next phone call you get is going to be the assistant U.S. attorney calling you and saying, hey, we're going to go ahead and decide your application. It's a wonderful moment. But just know that practically speaking, in these cases, it really comes down to the motion to dismiss. If you win the motion to dismiss, you generally win the case. I do have on here a motion for summary judgment. These cases almost never go to a motion for summary judgment, but I have it here just to explain what it is. So I said before, a motion to dismiss is when the judge assumes everything in the complaint is true and even then decides there is no case. Okay, so an example of this. Let's say you're wearing an orange shirt, someone sees you on the street and says, your orange shirt deeply offends me and is hurting me, I'm suing you, so you can't wear an orange shirt. That's the kind of case that's going to get dismissed. Why? Because they're going to file their lawsuit and you're going to respond and you're going to say, assume everything they've said is true. I was wearing an orange shirt. Okay, they were deeply emotionally offended. They were harmed by my orange shirt. It doesn't matter. I have a right to wear an orange shirt. It doesn't matter if someone's offended by my orange shirt. You can't file a lawsuit based on that, and the judge will dismiss it. That's what a motion to dismiss is. Assume everything is true that the complaint alleges, there's still not a case. A motion for summary judgment, though, is different. That allows you to bring in, and the other side, to bring in all of the evidence in the case. So it generally happens after discovery, after you've gotten all the emails, all the documents, and each side, generally speaking, makes their argument to the court, oftentimes through paper filing. So they'll file the lawsuits. File the motions for summary judgment. Oftentimes there can be cross motions for summary judgment. So both sides will say to the judge, decide in my favor based on the evidence you have, Your Honor. And the judge can take into account all of the discovery as it's argued in the filings. So you can see why motions for summary judgment don't usually happen. It's because you get to do discovery. And what the judge is doing there is the judge is being asked to reach a decision based on the facts and the legal arguments presented. Okay, so there's no assumption that one side got everything right, as there is in the motion to dismiss. You actually get to argue the facts. Okay, so that's the process. And the process, again, usually ends with the decision on the motion to dismiss. So let's talk through a few common questions. I've touched on a few of these. Can I file a mandamus action to compel the government to approve my petition? No, you cannot. A mandamus action is filed to compel the government to reach a decision, but it could be any decision. Once the government issues a decision, that lawsuit is basically over. If they just deny your application, they have reached a decision. If they've approved, they've reached a decision. So a mandamus action asks the judge to compel the government to act, not how to act. How much time must pass before the delay is unreasonable? This is very case specific. One of the first questions we ask is, what is the harm that was caused to the person? The second question is, what was the application regarding? An application for work authorization, for example, you may have less time. The government may have less time to decide it than, say, an EB-5 application or a non-immigrant visa application at the consulate. So you have to look at what the person's applying for and what the estimated processing times are for that, whether there is a law that specifically talks to the time frame. Again, naturalization applications, you have specific laws talking about the time frame. So what you're applying for, what has been delayed, is very relevant in these applications. How long does it take for a mandamus action to be decided? So I started talking about that and then I didn't finish. But first of all, usually the government gets 60 days to respond. That's usually extended to 90 days or so. Let's say that the government files a motion to dismiss. What would happen then is both sides would file their papers. So basically, they file a motion to dismiss. You get to respond to that through, again, typically a paper filing. You may have a conference with the judge, maybe a Zoom call, maybe a phone call to discuss the motions. And then it's up to the judge to decide. Judges can take months. Okay, so in our experience, if the government decides to settle the case, meaning they look at it and they say, you know what, we think we can decide this. That can happen in as short as 60 days or so. It's usually not going to happen faster than 60 days. If the government files a motion to dismiss and they decide to litigate, this application could take 6 months, 9 months, a year before you get a decision. So don't think that a mandamus can necessarily be a fast solution. It's not uncommon for these cases to take 6 months to a year, even if they're moving reasonably quickly with the judge. Okay, but if you've been waiting for an EB-5 application for 4 years, 5 years, as some of our clients in the past have, waiting a year for the judge to chime in and tell the government what to do can definitely be worthwhile. Won't the government simply deny my petition or retaliate against me if I sue them? This is a very reasonable question, and I will say that in the past, the answer was basically almost always no, that the government would not retaliate. I think now there are questionable cases where did the government actually deny my application as a result of me suing them. I will say it is not common for that to happen. So if that is happening, and I'm aware of maybe 1 or 2 examples out of dozens and dozens and dozens where the government may have denied the application because a mandamus lawsuit was filed. The number is very small, and that's an assumption. There's usually, clearly no direct line. You're not going to find an email where the government says, they filed a mandamus, deny their application. So it's very difficult, if not impossible, to know. So even if there is some retaliation, the number is extremely low. The takeaway is I do think that a mandamus lawsuit for most situations is a very reasonable decision and is not going to result in a negative decision from the government. That being said, is there a risk? Yes, there is. There's not a zero risk here. So I think there is some risk that the government could retaliate against you, especially given the current environment regarding immigration applications and the current administration. My delayed application is with a U.S. consulate. Can I file a mandamus action against a consulate? This is an excellent question. The answer is yes, you can. But here is the thing to keep in mind. What you're likely to learn about if you start researching this a little bit is something called consular non-reviewability. This is something that's really interesting. Basically, the Supreme Court of the United States has decided that consular decisions, the decisions of consulates regarding visa applications, are not reviewable by courts. So if you're applying for a visitor visa, and the consulate denies your application, and you think it was completely illegal for them to deny your application, you, in general, cannot sue in a court to overturn that denial. That is not the case with USCIS. If USCIS denies your application and you think it was bogus, completely wrong, you can sue USCIS. But keep in mind what I just said about the consulate. If they deny your application, you, generally speaking, cannot sue them. Mandamus actions are not challenging a denial. What they're doing is challenging a delay. consulates still have to reach a decision on the application. They have an obligation to do that. So you certainly can file a mandamus lawsuit against a consulate if what they are doing is just delaying the application, if they haven't reached a decision. And this is true even in administrative processing cases where you'll get, say, a 221G notice that we're putting your application into further security review, whatever it is, and you get a 221G. It's sometimes called a 221G denial, but that can be confusing because the case is still open at the consulate. They are just doing a security review. They just have to, in their system, pick approved or denied, and because it wasn't approved, they have to pick denied. But the case is not closed. They're still deciding it. They're doing a security review, for example. In those cases, you can still sue the government. And they may say, hey, 221G, this is a denial. It's not a denial. And you can argue in court, this is not a denial, it's a delay. Yes, you can sue a consulate. Should I work with a lawyer if I decide to file a mandamus action against the government? Our recommendation is yes. Federal litigation is not easy or straightforward. You do want someone who understands the federal rules of civil procedure, the rules of the court where you're filing, who understands where you can file. That alone can get complicated. You also want someone with experience working with assistant U.S. attorneys. That is hugely helpful. And I will tell you from the perspective of a lawyer, in cases I've handled in the past, not necessarily in this job, but in other jobs, when the other side is not represented by a lawyer, it makes the case much more difficult. Lawyers tend to understand the odds of getting to your ultimate goal and the best way to get there, the most efficient way to get there. And when someone is not represented by a lawyer, they sometimes don't understand how they may have either a weak case or a strong case based on the law and based on the rules and based on the timing. So I do think working with a lawyer can help a lot in these cases for those reasons. And obviously, I'm setting aside even, immigration law. Immigration law is extremely complex. So you do want a lawyer who knows how to find those statutes that will help you, who can find the data to make the best arguments that the government's delay is unreasonable. If there are questions, feel free to send them in. I did want to talk about something that I mentioned before. When I was talking about how these cases do tend to look the same, basically in almost all, I shouldn't say that, in the majority of mandamus cases, what the court is going to look at are what's called, to decide whether the delay is unreasonable, are what's called the track factors. That's TRAC, track factors. This is from a case from several decades ago involving the FCC. It wasn't an immigration case. But basically, it is the case where the courts established the framework to decide if the delay has been unreasonable. So in these cases, that's the argument you're making. You're arguing the delay has been unreasonable. And to show that the delay has been unreasonable, you need to establish that these track factors, there are 6 of them, weigh in your favor. So the track factors are going to look at things such as the harm you faced. Have you faced harm? Has the delay caused you harm, I should say? Is there a procedure? Has the government established a procedure to process these applications? And is it following that procedure? You're going to look at things like, is there evidence that the government's resources are being used in a particular way that weighs in favor of either party? Is there evidence of almost bad character? The last of the 6 track factors actually looks at whether there's almost intent behind the delay. And this is an example where you can pull in some really good information. USCIS has changed its mission statement to say it's not a customer service organization. That's no longer its mission, even though it used to be. There are lots of public statements made by our president, by the head of Homeland Security, by the head of USCIS. that you can bring into your lawsuit to talk about the intent behind these delays. So we are not shy about bringing those things into our lawsuits, and I think it is important to do. I think it does make the lawsuits stronger. But when I said before that the framework is very similar, regardless of what the delay is you're challenging, what benefit it is you're applying for, whether it's a visa, a green card, work authorization, etc., it's generally those track factors that you're going to have to meet in the application. And I do think, again, because we're suing the government, there's a lot of great information out there, whether it's quotes, press releases, data, historical data. There's really good information out there. So you do want to pull that into your complaint to make it that much harder for the government to win on its motion to dismiss. All right, that is what I have for you all. I hope this was helpful. We will post this recording to YouTube in case you'd like to watch it again or share it with anyone. We'll also send the PowerPoint presentation. I'm sorry that I missed the first couple slides and didn't share that on my screen, but do check out the email afterwards. Since we have a little time, I'll just quickly show the first two slides going over what a mandamus action is. Again, we'll send this to you, but if you're watching on YouTube, you can pause and look at this as the outline. And then what makes a strong mandamus case. And then finally the process. So I think all the other slides we went over. All right. If you have any questions, please do reach out. Schedule a consultation. We'd love to talk with you about your specific circumstances. In the meantime, stay well. We look forward to talking with you. Thank you.